Full name, sir?
My name is Carlos Lorenzo of the family.
Hold on a second. We already know who Carlos from the Durham family is because he was just covered recently. His name has been popping up again, and for good reason, since his behavior keeps drawing attention. This isn't some random individual showing up out of nowhere. There's already a clear pattern forming. When you look at the bigger picture, it becomes obvious why his situation keeps resurfacing. Let's slow it down and take a closer look at what's really going on here.
Family, and I'm here as executor of the estate named in this matter.
Hey everyone, welcome back to today's video. It turns out that a member of the Durham family failed to respond to earlier court instructions and did not appear for the scheduled date. As a result, authorities stepped in and brought him in to make sure the process moved forward properly. From this point on, there's no question that future court appearances will be accounted for. With that context in place, let's get started and break it all down.
The court is scheduling a pretrial February 14th, and this is in regard to case B1245821, August 25th, 2021. No dog license. Same date, time, and location for B124582221, August 25th, 2021. Failed to vaccinate dog against rabies and or provide proof of vaccination. 3 additional matters. One at a time. State your full name, Mr. Durham.
Lorenzo of the family, Durham.
Chair.
Sheriff, I'm asking Mr. Durham for his formal reading understands his constitutional rights and
For waive formal reading and or plea of not guilty. Mr. Durham, the court scheduling a pretrial date on this matter via Zoom. You must attend February the 27th, 8:30 a.m., 36th District Court in front of Judge Bryant. Understood?
Yes, you are currently in custody, so it's clear that you can hear what's being said. But that wasn't the point of the question. What really mattered was whether you actually understood what was being explained to you. Given the past confusion around your court responsibilities, it makes sense for the officer to seek clear confirmation. The goal here isn't repetition, but clarity and acknowledgement. Under the circumstances, asking if everything finally makes sense is completely reasonable.
Mr. Durham, and the court has concerns that you missed a court date on this matter, as well as 2 other matters that we're about to handle. And your capious history, Mr. Durham, tells the court you do not listen to the court as ordered to appear, and that's concerning where if the court were to release you on another personal bond, sir, you treat it as you have in the past and disregard court's orders and simply not appear. And that's unacceptable, Mr. Durham. You must appear as ordered. So the court, based on your capious history, take into consideration the information presented by counsel, including that limit to employment status as relates to ability to post bond, the nature of the charge, as well as the information alleged in the investigator's report, is setting, based on your capious history, is going to continue the bond set by Judge Bryant of 110%. Is that an affordable bond?
it's not.
Okay, so on that matter, the court is setting an unaffordable bond redetermination hearing.
I'm not here to judge anyone based on their financial circumstances because those situations can change for many reasons. Still, it's difficult not to notice how certain choices can lead someone into serious long-term trouble. When decisions begin limiting even the smallest options in life, it's often a sign that something needs to change. At that point, continuing down the same path doesn't make much sense. Sometimes the smartest move is stepping back and choosing a completely different approach.
Or any dangerous weapon, and you are not to drive any motor vehicle unless you have a valid driver's license. Is that understood?
Drive, Your Honor. I travel. I'm not driving ever again in life. I travel, so I don't need a license.
Here we go again. Another person presenting a travel card while insisting that operating a vehicle on a public roadway is no different from moving on foot. That comparison overlooks some very basic distinctions that have already been explained countless times. Walking from one place to another inside a facility is not the same as driving a motor vehicle in public spaces. The rules and expectations are clearly different, even if some choose to ignore that reality. Moments like this show just how far removed some arguments are from common understanding.
No traveling behind a motor vehicle. I'm not arguing with you, Mr. Durham. I'm telling you. Excuse me?
I've already read the Supreme Court case law. I have a right to travel, sir.
Okay, well, I have a right to impose bond and conditions of bond, Mr. Durham, and I'm telling you, whether you call it traveling or driving, there's to be none of that behind a motor vehicle. You're not to travel if you're operating a motor vehicle or drive. No driving or operating of a motor vehicle, regardless of what you call it. Understood, Mr. Durham? No driving or traveling if you're the operator. Is that clear? And you're not to leave the state of Michigan. Is that understood?
I heard you.
And that's no driving, period. That's regardless of your license status. There's to be absolutely no driving. Or traveling. Okay, I said no traveling either.
Driving is
No
operating.
traveling. Just put that as a positive. No traveling.
So that means I can't even go to court if I can't travel. I can't leave my house.
It's via Zoom. It's via Zoom. It's via Zoom. No traveling. The court dates are via Zoom. No traveling unless court ordered.
That's a violation of my rights. And I will appeal this in a higher court.
Did you want to address his traveling, counsel?
I'm sorry.
Did you want to address his argument that he can't, that he can travel?
He's going to comply with court orders.
And that means no driving and no traveling. Is that correct, counsel? No traveling unless court ordered. Yes, I can't leave the state of Michigan, and he cannot. Would he drive or travel? Which, my understanding is him operating any motor vehicle. Is that understood?
I actually appreciate this judge's approach because he keeps things practical and straightforward. When someone refuses to acknowledge basic realities, the court adjusts its orders to remove any room for confusion. Instead of debating definitions endlessly, the judge sets clear limits that apply no matter how someone chooses to frame the situation. That way, every possible angle is addressed without unnecessary back and forth. It's a firm, efficient response that keeps the process moving forward.
This is a very serious allegations. Again, you have a capious history on this matter. The bond was set by the judge when you failed to appear. You have a number of capious histories on this matter. It looks like you were originally given a personal bond, then you failed to appear on about September 1st of 2022, given a $10,000 cash surety, and then you failed to appear again December 14th of 2022, and then a judge will give you another $10,000 cash surety. I, as a magistrate, as counsel stated, have no. One moment, I'll let you address the court. One moment, Mr. Durham. Have no authority to amend the capious bond as set by the judge for your failure to appear. So for that reason, the bond is going to be continued as set by the judge of December 14, 2022 in the amount of $10,000 cash surety. During this bond, you are not to purchase or possess a firearm or any other dangerous weapon. No driving, no traveling unless court ordered. You will be fit with the GPS tether under house arrest if you're able to make bond. And no use of any alcohol or illegal controlled substance. Is there anything further, counsel?
I would respectfully ask the court to reconsider the GPS tethering under.
He's missed court in every matter before the court this morning, so no.
Thank you.
You're welcome.
No, I haven't.
Anything?
I done came to court a couple times on Zoom, on a tether. I done been to court.
But not all of the times it does not appear, Mr. Durham. It looks like you missed court more than once on that matter that we just handled. Anything else on this matter, counsel?
On account of the county jail. I missed court on account of the county jail. They wouldn't take me to court. I missed court because of the county jail would not take.
Of course, Carlos, none of this ever seems to be your responsibility, and it's always someone else to blame. It's framed as the system's fault for enforcing schedules, requirements, and expectations that apply to everyone equally. Accountability is often redirected rather than accepted, even when the choices involved are clear. Over time, that pattern creates a cycle where responsibility is never owned. And as the saying goes, when every situation feels unfair and everyone else seems to be at fault, it may be time to look inward and reassess.
Capious on this matter as well as the matters before the court previously, and that demonstrates to the court that you failed to appear as ordered, and that's concerning regarding your intention to appear and handle this matter. It looks like you were on a personal bond by the Honorable Magistrate Ramsey Heath, where you failed to appear on or about December 14, 2022, and a bond was issued at $10,000 cash surety. I, as a magistrate, have no authority to change that bond as set by the judge. So the bond is going to be continued, taking into consideration any employment status presented by counsel as it relates to ability to post bond, as well as your capious history. During this bond, no use of alcohol, no illegal controlled substance. You're not to purchase or possess a firearm or any other dangerous weapon. If you're able to make bond, you will be under house arrest, fit with the GPS tether prior to release. There's to be no driving and no traveling.
You can't help but feel a bit of sympathy for Carlos from the Durham family, because his frustration is written all over him. Each time the judge explains the current limitations, you can see the disappointment settle in. It's clear that mobility is the one thing he values most, and hearing those reminders clearly weighs on him. The contrast between what he wants and what he's allowed to do is hard to ignore. Moments like this show how strongly personal priorities can clash with legal boundaries.
Reported. Anything you say can and will be used against you. And on that matter as well, you're getting an unaffordable bond redetermination hearing on January the 19th, 2023. Judge Sabri at the 36th District Court via Zoom. Do you have any questions or statements, Mr. Durham?
Yes, I do. This question is to
Go
you,
ahead.
the magistrate. Are you honoring your oath to the court?
Before you say anything,
This is your turn.
everything you say right now kind of that's where I need to. Please do not say anything right here. I feel like actually because I try to protect you, okay?
That was your attorney speaking and giving you a
But, Your Honor, the argument being made suggests that the attorney is mistaken about the need for a driver's license to operate a vehicle. That perspective dismisses well-established requirements that are commonly understood and consistently applied. Legal counsel relies on those standards when presenting a case, not on personal interpretations. Continuing to challenge settled rules doesn't change how they function in practice. With that in mind, the court proceeds based on what the law clearly requires.
I don't know what type of question that is, Mr. Durham. Did you have your counsel has indicated you have a right to remain?
Now you don't know what it means. You took an oath to uphold the Constitution, didn't you? Are you honoring
I don't
your
know
oath?
what the purpose. I don't know what the purpose. I'm not here to answer your questions. I can tell you that, Mr. Durham, as far as regarding questions that don't have anything to do with the arraignment. I'm not here to just answer random general questions that have nothing to do with your arraignment, Mr. Durham. So if you have any questions regarding your court date, you can please let me know.
I want to know who you are. You won't tell me your name. You won't tell me if you're bonded. You're a public official. Are you bonded?
Mr. Durham, I'm not going through it. Mr. Durham, I'm not going through that, the nature of my employment.
You got to give me your bonding information, name, address, and your policy number so I can make sure you're adequately insured. Just in case you want to violate my rights, I got to make sure you're adequately insured. Are you a public official and are you insured?
My name is Chief Magistrate Winfrey Coker. I've answered that question regarding binding, Mr. Durham. That's not something that's going to be addressed today.
So you're not going to put that on the record?
I'm just not entertaining a question that makes no sense during the arraignment, sir.
No, that interpretation doesn't hold, and it's already been made clear who is presiding over this matter. The judge has explained his role and authority, while also noting the pattern of missed appearances that led to this point. Today's proceeding isn't about debating roles or revisiting settled issues. It's about moving forward within the structure already established by the court. For that reason, no additional requests or conditions are being entertained at this time.
I'm bonded if that makes you happy, Mr. Durham. I do have a valid, as indicated by statute. Mr. Durham, I'm not getting back and forth. Counsel, do you have anything further with Mr. Durham?
Number of the bonding company. Can I have any of that so I can contact them? I got to be able to contact them.
No, Mr. Durham, I'm not. I gave you, I let you know I was bonded. My name is Chief Magistrate Coker at the 36th District Court. That's the information. Okay, counsel, we can try anything further. Mr. Durham, I've said more than once, we're not going through that here today on the record. So, Mr. Durham, if you have any questions about your arraignment or court date, otherwise, we're through with the arraignment. Counsel, do you have anything further?
To give me the name of the bonding company.
Unless you have anything else, Mr. Durham, we're through with the arraignment.
Alright, that wraps up today's video, so thanks for watching everyone. After this, Carlos had 2 more quick court dates, with an additional 3 scheduled for a few weeks from now, and our next video will dive into those next appearances. Wayne County Jail also addressed the earlier missed court issue, which unsurprisingly didn't make Carlos very happy. If you enjoyed the video, go ahead and hit that like button. And if not, leave a dislike. Either way, let me know your thoughts in the comments below. Don't forget to subscribe and turn on notifications so you won't miss any of my future content.